Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 84, which is going to be the last of our regular series of podcasts this year. But stay tuned, and I'm going to tell you about a special one-off podcast that we're going to do between now and Christmas. Anyway, in this, the regular podcast, we're going to be looking at three cases. No surprises there, of course. The first, it's a Supreme Court decision in relation to implied terms in contracts of employment. Well, in terms of contracts in generally, I should say, but we're going to look at it, obviously, in the context of contracts of employment. And the case is particularly important in the employment context, as implied terms are a fundamental feature of the employment relationship. Secondly, we have an EAT decision concerning the Tribunal's requirement to consider events following an alleged service provision change under TUPE. The key question the EAT considers here is whether, in assessing the client's intention for the services to be provided only temporarily, it is appropriate to consider the position after the relevant transfer date as well as at the time of the transfer. And the third is an Employment Tribunal decision. So we've got Supreme Court through to Employment Tribunal decision, and the Employment Tribunal decision looks at a claim for discrimination arising from disability and an allegation of a failure to make reasonable adjustments brought by an employee who was unsuccessful at a job interview. And if you stay tuned through all of that, then, as I say, I've got news of the special episode that we're going to do shortly, and a forerunner of the Christmas competition, and also, by way of a give back, a recommendation for a podcast, non-legal podcast, of course. Wouldn't want to be recommending any of the competition. As ever, I ought to just say that we are this podcast is available via iTunes and Mayor Brown's internet, as well as on Twitter, Nicholas Robber, ROBER 11, where I will put up links to the cases, and case names and so on are available if you are logging into this via YouTube. So that's enough of the formalities. On with the first case. So that's BNP Paribas Securities Services Trust Company, brackets Jersey, brackets Limited, and another. And as I say, Supreme Court decision looking at implied terms. Whilst the case, as I say, isn't in the employment context, it is important for our purposes because it provides authoritative guidance on when terms are to be implied into contracts. And the guidance will be followed by employment tribunals when interpreting employment contracts. By way of background, contracts are made up of express and implied terms. Express terms are the terms that are agreed by the parties, obviously, often written in contract, but express term can be made verbally. Implied terms, on the other hand, are terms that are read into a contract by the court for one of three main reasons. And the first is, it's implication by fact, and this happens if either it's necessary to imply the term to make the contract work properly, business efficacy, or if it's so obvious the term must have been meant to be included in the contract but the parties forgot to do so. This is the so-called officious bystander test. Second reason why terms can be implied is if it's common law statute, minimum wage, that sort of thing. Third reason, custom and practice. So the classic example, of course, is the continued practice of offering enhanced redundancy payments that everyone in the workforce knows the formula and how it's calculated, and it's been publicly acknowledged, for example. Well, this case focuses on the first category of implied terms, those implied by fact. And there have been many cases in the area, and they've dealt with the question of when a court should imply a term into a contract. And the key tension being that the courts need to be careful so as not to fetter the parties' freedom to contract by implying provisions into the contract that the parties did not intend. And of course, implying terms into a contract, almost by its very nature, is potentially very intrusive. So it's important that there are clear boundaries as to when a court will do this. Background facts. not particularly important for our purposes, but I've just mentioned them briefly so you know. And it was to do with a commercial tenant, which exercised its right under a break clause in the lease to end the lease 4 years before the expiry of the term. However, the key issue was the tenant already paid quarterly rent in advance and wanted to recover the proportion of rent paid for the period after the lease had ended. There were no express terms, and therefore the tenant argued that the court should imply a term into the lease, entitling it to a pro rata share back, and that required the court to consider the principles regarding implied terms, and it ultimately ended up going all the way to the Supreme Court. Pausing there, it's important to mention that the reason the Supreme Court took this opportunity to set out the principles governing implied terms was because there had been some uncertainty and confusion following a Privy Council decision called Belize back in 2009. And after Belize, it had been suggested by some commentators that the Belize case had enlarged, really, the boundaries for the courts and enabled them to imply terms into a contract on a more liberal basis. In the present case, however, the Supreme Court held that Belize should not be understood as watering down the traditional tests, and therefore the well-established pre-Belize case law should be followed. So the Supreme Court went on to emphasise the main principles that should be applied when considering whether to imply a term into a contract. 1. The business efficacy test and the officious bystander test are really two separate tests, and only one of them has to be satisfied for a term to be implied, although inevitably in practice it's likely that they will both be satisfied at the same time. The key focus is not in general terms about reasonableness, nor should a term be implied simply because it would be fair to do so. It's helpful to think of the business efficacy test as, another way of putting it, would the contract lack commercial or practical coherence if the term wasn't implied? The officious bystander test should be phrased in an objective and neutral way if you're asking yourself a question, so as not to predetermine the outcome of the test itself. I think the case is overall a pretty helpful one for employers. Why do I think that? Well, since the average contract of employment or contractual documentation would be prepared by the employer, you'd expect the document to start from the position of reflecting the employer's interests over the employee's. To that extent, it's more usually going to be the employee who is seeking to avoid a literal interpretation of the contract, producing what the employee considers to be an unfair result. In that context, a statement by the Supreme Court that the key focus is not about reasonableness, nor should a term be implied just because it's fair, is particularly important. In other words, the Supreme Court is warning other courts, or employment tribunals for that money, away from implying terms to address any perceived imbalance in negotiating power going into the contract, respecting the freedom of people to contract. Also, the Court has confirmed again that a term cannot be implied if it would cut across an express term of the contract. And I've always wondered why we've not seen employers trying to exclude the duty of mutual trust and confidence, for example, on the grounds that normal contractual interpretation would mean there was no scope for such an implied clause if it was expressly excluded. Come on out there, someone's got to be prepared to take a chance. Ultimately, there's no doubt the best approach is to ensure the contract is sufficiently clear in express terms so people know where they stand. There's less scope for misunderstanding. But equally naturally, we all recognise that's a counsel of perfection. And let's face it, if everyone took it, then we'd have no need for employment lawyers, which would be a thoroughly bad thing. I'm sure you'll agree. Well, that's the case of BNP Paribas Securities and another. Next up, ICTS UK Limited and Maddie and others. This is an EAT decision looking at TUPE service provision changes and whether the events that follow an alleged service provision change are relevant in determining whether the customer's intention was for the contract to be awarded short term and therefore be outside the scope of TUPE. Let me explain. Under the TUPE regulations, a service provision change may arise where a client decides to outsource its services or elects to reassign its outsourced services or bring those services back in-house following an outsourcing. However, there is an exception under the TUPE rules where services are intended to be tasks of a short-term duration, effectively a one-off event or just provided on an interim basis. In such circumstances, where that's the intention, TUPE will not apply, and the alleged transferee can rely on this duration exemption to sidestep the regulations entirely. It's an important case because there's no doubt the general thrust of the law is to find that there is a TUPE transfer, so that anything that goes against that natural inclination needs to be clearly understood. In this case, further guidance on this exemption has been provided by the EAT. The background was a group of ICTS employees were employed as security guards at the former Middlesex University campus. However, on the sale of the campus to a Malaysian organisation, AUCMS, ICTS continued to provide security service at the campus. So at that precise point, there was no duty transfer for ICTS staff. However, shortly afterwards, the contract was re-tendered and went to a new contractor, First Call. At the point that First Call took over the security contract, the ICTS employees lost their jobs. ICTS and First Call disagreed on whether or not there had been a transfer, with First Call arguing that its contract to provide security services was only an interim measure until a major redevelopment of the Middlesex campus was completed. First Call therefore argued that TUPE did not apply, refused to take any ICTS employees in reliance on the tasks of short-term duration exemption. ICTS and the individuals subsequently brought claims against First Call. In an earlier case, Horizon Security Services, it's been established by the EAT that the test to decide whether or not there's a short-term exemption is what the customer intends to happen at the point of transfer. In line with this approach, in the ICTS case, the Employment Tribunal agreed with First Call the contract had been entered into by the customer with First Call, with the intention that First Call would only secure the unoccupied site for a limited period pending construction and completion of redevelopment. The Tribunal looked at the customer's intention at the relevant date of transfer in coming to its decision. Its conclusion was that the unoccupied site would not remain unoccupied for long, and so it held that the activities were of a short-term duration, and therefore TUPE did not apply to transfer the ICTS employees to First Call. Crucially, however, the Employment Tribunal said it was not appropriate to consider events following the date of the alleged transfer, arguing these were not legally relevant. ICTS appealed the decision because, of course, if the transferee wasn't liable, then it was. So ICTS appealed the decision to the AT, arguing, amongst other things, that the Tribunal had erred in not considering events after the transfer date. In putting forward its case in the Tribunal, ICTS had provided evidence that, at the date of the Tribunal hearing, planning permission had not been granted for the redevelopment of the site, and that's at the date of the Tribunal hearing. No works had yet started on the project. They therefore challenged the assertion whether the security for the unoccupied site was really intended to be a short-term task. The EAT agreed with ICTS, holding that events after the alleged date of transfer can be taken into account by the employment judge. The EAT agreed with the Tribunal that it's necessary to consider the client's intention for the services at the time of the transfer. Fine. But said it may also be important to consider subsequent events. Here, the EAT held the Tribunal could have factored the lack of planning permission and failure to start work at the site into its decision as potentially being relevant to establishing the client's intention for the services to be of short-term duration or not. The case was therefore remitted to the Tribunal for a rehearing, and as they say, the case continues, so we don't know whether the Tribunal will remain of the view that the task is of short-term duration or whether it will change its mind. First point to make is that I think the EAT's decision is entirely logical. If a customer, in this case the owner of the land, does something after the event which indicates that it is most unlikely to have been their intention that the task was to be of a short-term duration, why should that be excluded from the Tribunal's consideration? To take a really simple example, if the client, on the day before the alleged transfer, sends a contract which is due to last a week for services, and then the day after the transfer sends a contract that is due to last 5 years, why should a tribunal be precluded from taking that second contract into account in deciding what the client intended to do at the point of transfer? So the lesson for parties engaged in TUPE transactions is to ensure that it's not possible to muddy the waters by acting in a contradictory way after the alleged date of transfer. Equally, if events change so that the customer's intentions change, it would be a good, in fact, it'd be a really good idea to make sure there is contemporaneous documentation recording the change in facts or plans so that the change in approach is explicable. To this extent, the approach here mirrors the approach taken in discrimination claims, where it's long been established that events after the date of the alleged discrimination can, in theory, be logically relevant in establishing what was going on at the point of the alleged discrimination. The other point to mention is the tribunal is looking at assessing customers' intentions. And obviously assessing a customer's intention is difficult. It's not a straightforward task, which is why I think they're looking, a bit like with discrimination, at evidence wherever it might come from, to try and cast light on motivation. In previous cases, the EAT has said that the intention must be more than a hope and a wish. It may be, therefore, helpful for any employer or contractor to have solid documentary evidence they can rely on if they plan on arguing the short-term exemption under TUPE in front of a tribunal. This would be all the more relevant where subsequent events seem to contradict the party's intention at the time of the alleged transfer. So, that's the case of ICTS UK Limited and Maddie and others. Third and final case, Waddingham and NHS Business Services Authority. And this is a tribunal case which looks at a claim for failure to make reasonable adjustments and discrimination arising from a disability. The claim was brought by an employee who was unsuccessful at a job interview at a time when he was undergoing treatment for cancer. Although this is only an employment tribunal case, I thought it was well worth including because it's a useful illustration of the sort of dangers for employers offered by the DDA provisions. By way of legal background, Section 20 and Schedule 8 of the Equality Act 2010 contain provisions in relation to the duty on employers to make reasonable adjustments. If the employer operates a provision, criterion or practice, known as a PCP, that puts a disabled person at a substantive disadvantage when compared to the person who is not disabled, an employer must take reasonable steps to avoid such disadvantage. The employer is only expected to make such reasonable adjustment if they know or ought to have known that the employee had a disability and was likely to be placed at that disadvantage. Section 15 of the Equality Act contains the provisions regarding discrimination arising from disability. That section states that a person discriminates against a disabled person if they treat the disabled person unfavourably because of something arising in consequence of their disability, and the employer cannot show that the treatment is a proportionate means of achieving a legitimate aim. The background facts of the case concern Mr. Waddingham, who had worked for the NHS since 1984 in a number of different roles. As part of an NHS reorganisation, his role was due to end in March 2013. He was informed he was at risk of redundancy. He therefore began looking for other roles, one of which was that of Client Relationship Manager, or CRM for short is what I'm going to call it. In late 2012, however, Mr. Waddingham was diagnosed with throat cancer and early in 2013 began radiotherapy treatment. During the time, Mr. Waddingham continued to look for alternative posts and formally applied for, you guessed it, the CRM post. There were a number of applicants for this role, and so the NHS decided, in line with its normal and standard arrangements, to interview the applicants and require them to score for 75% in order to be successful. The NHS arranged Mr. Waddingham to be interviewed, and in light of his disability, they arranged the interviews to be conducted at a location to suit Mr. Waddingham's needs. Also, Mr. Waddingham was told he could take a break at any time during the interview, or stop the interview and rearrange it if necessary. He was pretty upbeat about the interview, it has to be said. But the outcome was that Mr. Waddington only scored 54% and therefore did not obtain the post, as he himself had not reached the required score of 75%. As a result, he was given notice of his termination of employment in March 2013, and Mr. Waddington brought claims. He brought claims for failure to make a reasonable adjustment and discrimination arising from his disability at the Employment Tribunal. Well, the Employment Tribunal found in favour of Mr. Waddington on both counts. In relation to the reasonable adjustments, the Tribunal found that there were two PCPs in play. The first was the PCP requiring Mr. Waddington to attend a competitive interview, and the second was a PCP requiring him to achieve a score of over 75%. The Tribunal found that both PCPs put Mr. Waddingham at a substantial disadvantage in comparison to persons that were not disabled. His performance at the interview was adversely affected because of his cancer therapy and all its effects. This had caused Mr. Waddingham severe difficulties in being able to prepare for the interview and being able to perform to the required level. Whilst the tribunal found that Mr. Waddington had put a positive spin on his condition during this time ahead of the interview, the tribunal found this did not absolve the employer from its obligations to consider properly whether any reasonable adjustments should be made. Ultimately, the tribunal held that the NHS were aware of Mr. Waddington's illness and that he was disabled and that the treatment he was receiving, and therefore they should have assessed Mr. Waddington without asking him to come to the interview on the basis of his past performance during his long service with them. Now, the tribunal stated it did not think it was necessary to have had a lower pass mark or for the interview to have been delayed for everyone so that no one was appointed for a prolonged period. So they did say that in some respects what the employer had done was fine. But, as I say, this core finding that the tribunal made was that they should have assessed him without asking him to come to the interview. In relation to discrimination arising from disability, the tribunal were quick to find that this was made out on the facts of the case, and so Mr Waddington's claim succeeded. He was not appointed to the CRM role because of his poor performance at the interview. That poor performance was adversely affected by his disability. The NHS tried to rely on the objective justification point by suggesting that the legitimate aim was selecting the best candidate for the post. However, the tribunal doubted whether that was a legitimate aim and suggested that a more appropriate legitimate aim would have been to have found the candidate who could perform the role to the required standard. Either way, the tribunal held that requiring Mr Waddingham to undertake a competitive interview was not a proportionate means of achieving that aim. I think the case is useful. It highlights factors which an employer should bear in mind when considering making reasonable adjustments. But it's important to remember that the duty exists whether or not the employee puts, quote, a positive spin on their disability, or whether or not the employee asks for any adjustments to be made. I do think the case goes some way to highlight the grey areas in relation to the duty to make reasonable adjustments. It was clear in this case that the NHS had gone some way to try and make reasonable adjustments for Mr Waddington, i.e. they'd been flexible in the timings and location of the interview, but the tribunal held not enough. The tribunal, as I say, did accept that lowering the pass mark for him or delaying the interview process was not a reasonable adjustment. And I think that really shows the ambiguity and difficulty in knowing with certainty what exactly an employer needs to do in order to have satisfied the obligation to have made reasonable adjustments. For example, would it have been a reasonable adjustment in this case to have made these adjustments if the employee had not been a long-standing member of staff? In this case, it was possible for the NHS to look at previous appraisals and to assess Mr Waddington without him coming to the meeting. However, in circumstances where that's not possible, it's difficult to see what reasonable adjustment might be required. I think the other point of uncertainty is the employee put a positive spin on their ability to attend the interview. The tribunal said this was, quote, immaterial, unquote. However, if the employer had said that they were not going to give him an interview but were going to assess him on paper, then I think I would have been concerned that this might have amounted to disability discrimination itself. So possibly the mistake on these facts was to go through the interview process and when he had failed to come up to the required standard, undertake a second stage process simply provided for him. And this could have involved checking his prior records, etc., to see if he'd been uncharacteristically poor performer on the day, or whether his performance and his answers matched what you'd expect him to say. Ultimately, I think the case emphasises the importance for employers when remembering that the duty to make reasonable adjustments is quite wide, and they will need to think laterally in terms of what possible adjustments to be made. To take this case as an example, it may not be enough to simply be flexible in relation to the process of holding an interview, but employers may also need to go that one step further and consider whether an interview is needed at all. However, let's not forget, this is only an employment tribunal decision, and so I put it in there as just an illustration of some of the challenges that disability discrimination causes for employers. So that's the case of Waddingham and NHS Business Services Authority. So I said at the beginning of the podcast that at the end of the podcast I'd be bringing you up to speed on three different things. First of all, we're going to do a special episode which is a list of the top cases for employers in 2015, trying to spread the net quite widely. So not necessarily all of the obvious ones, but all of them important cases. And we'll do a special podcast, and that'll probably come out within a day or two of this podcast. So keep your eyes and ears peeled for that, please. As part of it, and as an added lure, we have managed to snaffle Mayor Brown's holiday gift to the employment and benefits clients that we're sending out. And so we will have a quiz, and the winner of the quiz will get the Mayor Brown Christmas gift. Which I think it's fair to say is a gift of no practical application whatsoever, but hey, it's still a gift. And finally, podcast recommendation. I remember that 6-9 months ago I gave a recommendation for the podcast called Serial, as in Serial, rather than Thing You Eat for Breakfast. So Serial, the podcast, which I think went on to be the most listened to podcast of all time. And so I'm delighted to say that Season 2 of Serial has just started up. It's every bit as compelling as Season 1. And it's to do with a deserter, an alleged act of desertion by a US soldier fighting in Afghanistan. But anything that has the journalist phoning the Taliban to check her facts with them and then playing the recording of the ensuing conversation has got to be a podcast series worth a listen. So I'm not going to wish everyone happy Christmas, because I'm going to assume that everyone that's listening to this podcast will listen to the Christmas special, and I will look forward to doing that, as I say, in the next day or so and sending it out shortly. Thanks very much indeed. Take care. Bye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.